Hi everyone, welcome to this morning's SIEL conversation, investment treaties and the good governance narrative. My name is Caroline Henkels. I'm an associate professor at Monash University and a member of SIEL's Executive Council, and I thank SIEL for their support of the conversation series. I want to jump straight into today's discussion, which is about investment treaties and the idea that they foster good governance within the states that have signed them. Now, investment treaties were not always defended in these terms. In fact, this justification for the investment regime is relatively recent. But how did it emerge and why? And does it actually hold up in practice? Do investment treaties actually transform governance for the better? And which actors, if any, do internalise the disciplines of investment treaties? And so our panel today is going to ask those very questions. Where did this come from? And is it actually the case? Do these treaties improve government accountability, or do they entrench investor privilege and actually engender regulatory caution within states? And ultimately, does the good governance narrative reflect what investment treaties do for all the states that are party to them, or is it simply, I suppose, a rhetorical justification for the regime? Now, what we're going to do first is trace the evolution of this justification for the investment treaty regime, and then we're going to ask whether or not, according to the evidence, this rationale is actually delivering on its promise. Let me introduce our speakers in no particular order. Nicolas Perrone is professor at Universidad de Valparaiso. Lauke Poulsen is professor at University College London. Mavluda Satorova is professor at the University of Liverpool. Joseph Ostransky is senior policy advisor at the International Institute for Sustainable Development. And last but not least, Jonathan Bonicher is associate professor at the University of New South Wales. Now, I've asked our panelists to be succinct in their remarks, and I'm sure they will be. That's to ensure that we have plenty of time for our Q&A. And you're able to submit your questions at any time throughout our session using the Q&A function. So we'll start by unpacking the original bargain of the investment regime and the promise that was made to developing countries, namely that signing investment treaties would lead to increased foreign direct investment as a matter of course. Lauke, could we start with you? Would you be able to tell us about this first justification for the regime, this promise, and then what the evidence shows about investment treaties and FDI?
Yeah, sure. Thank you. And thank you, Karen, for inviting me here today. I look forward to the conversation. Well, first of all, I think it is just important to reiterate that there was a promise made time and again by many, not all, but by many capital exporting states and by several international organizations that by signing up to these agreements, developing countries would in fact be able to attract more capital. There's been an attempt, I think, in some circles in recent years to suggest that that was never really what this regime was about. But the message to developing countries from the 1970s and onwards, particularly the 1980s and 1990s, was to some extent largely about promoting foreign investment into developing countries. Now, I'm not going to sort of bore everyone because we've had large number of conversations around whether and to what extent that promise was fulfilled. And I suspect everyone who's called in today are aware of the large econometric literature on this, are aware that by and large, there's very limited effect at the margins, quite often no effects in that econometric literature, including in some of the meta-analysis that's come out. I don't think personally that's too surprising. The impact of these agreements are going to matter by the type of project, by the type of jurisdiction. But one thing I might just sort of perhaps provocatively suggest as a starting point is that I would suspect that if some of the studies that were undertaken 10, 15 years ago were repeated today, including some of the surveys of political risk insurance providers, some of the surveys of in-house counsel, for instance, in large energy firms, maybe the picture is different than it was when large part of this literature was sort of established 10, 15 years ago. Maybe given the amounts of awards that's been paid out, if we conducted the same surveys today, and if we had better FDI data than it was used 10, 15 years ago in that literature, maybe some of these agreements are more important today at the margin for certain types of investors than they might have been in the past. So if there's any PhD students listening out there, I think there's some low-hanging fruit to try and update that literature compared to where it's at currently. Thank you.
Okay, thank you so much. And I want to pick up on a sort of a related promise, this sort of trajectory that would happen after increased foreign investment or foreign direct investment, that economic development and greater prosperity would inevitably flow for those states, for those host states. And I want to turn to Jonathan, and here I'm actually asking you about something you two wrote along with Michael Weber a long time ago, but I think it's really great sort of background and context for us. So looking then at this idea of foreign investment, inevitably leading to economic development for that state, where's the evidence there? Is there any to support that claim?
Yeah, thanks. It's such an important question. And so just on, is foreign direct investment good for economic development? So leaving the question of investment treaties aside for one moment, very broadly and generally, the answer seems to be yes, it is good for economic development. But a more precise answer is that it really depends. So a lot depends on the sector and the project and how it's regulated. It's not just an overall picture. And so if we think about some types of foreign direct investment, they're often associated with very strongly positive externalities, so very potentially beneficial for economic development, knowledge transfer, the classic example being high-tech manufacturing that's often referred to. And then there are some types of other foreign direct investment which can be, especially if they're poorly regulated, associated with negative externalities, so negative potential impacts for economic development. And some of the examples often used here are extractive sector investment, particularly if it's poorly regulated. So it's a varied picture. Foreign direct investment can be positive for economic development, but that's not guaranteed. And I guess bringing the investment treaty question back in, one risk with investment treaties is that they're potentially least relevant in encouraging the sorts of foreign direct investment that is most beneficial from a developmental perspective, and most relevant, to the extent they are relevant, for encouraging the types of foreign direct investment that might have more questionable impacts on economic development.
Thank you. That's really helpful to sort of set that in context. And I suppose what I'm hearing is that the evidence to support both of these former justifications of the regime is mixed at best. Where effects exist, they're contingent, and certainly being a party to the investment treaty regime is not necessarily, if I'm understanding you correctly, the connection between being a party to the regime as such is not in itself a determinant of economic development, if I'm understanding you rightly. Now, I to my eternal regret, I never studied economics at university, so excuse me if I've completely misconstrued things. But what I want to turn now is to, okay, so these previous sort of justifications for the regime really never quite promised, never really quite delivered on what they promised, which led to this sort of mysterious appearance of a new justification for the regime, and one that is still, very much talked about today. And that is the appearance of good governance as the justification for the investment regime. Now, what is this mysterious beast, and how did what led it to emerge as a justification for the regime? Mavluda, I'd like to turn to you if you could explain the emergence of the good governance rationale and what it might even mean, at least in theory.
Well, apologies if my voice doesn't hold up. Been suffering with a bit of cold here. I can drone on about it for hours, but I'll try to be as brief as possible. So the good governance narratives actually are not old, and we can trace the roots of those as early as the beginning of the 20th century with the famous Allow Roots speech about the international minimum standard and what is expected of governments in treating foreign investors. But when it comes to the investment treaty regime and investment arbitration in particular, we see a particular proliferation of those narratives that coincides with the boom in investment arbitration cases, the numbers rising, and the number of awards rendered against developing countries. It was that time when it seems that a need emerged for additional justifications, for additional conceptual grounds on which to place investment law and investment arbitration. And that's where we see good governance rhetoric entering both the black letter of international investment law, including cases such as Metalclad, TechMed, Occidental, where we see arbitral tribunals articulating various elements of what constitutes good governance on, well, in developing countries. And that is essentially the requirements of stability, predictability, transparency, consistency, and all of those were enshrined in the emerging interpretation of the fair and equitable treatment standard. So foreign investors are now expecting developing country governments to behave in accordance with those hallmarks of good governance. And if governments fail to abide by those standards of good governance, then they will have to pay damages awards. So the mechanics of good governance and how it would then provide that additional justification for the investment treaty regime and its more expansive interpretations and painful consequences for developing countries is as such. So if originally it was deemed that the core mission of investment treaty law was to protect investors against certain egregious forms of behavior by the host government authorities, then and the benefits would be primarily for foreign investors, then now we see that, well, good governance would ultimately benefit host state communities and the society in general, because once facing the painful consequences of damages awards, developing country governments would repent and reconsider their bad behavior and introduce large-scale reforms, discipline their bureaucracies, and the government machinery as a whole. And that is how good governance rationale started creeping up in various legal texts and academic literature.
So it's actually a bit different to how I had understood this to have arisen, because my understanding was that this was the good governance narrative was sort of created you know, by those states and international organizations that sort of promoted investment treaties, but you're suggesting that it came from tribunals. Is this a kind of a joint effort, perhaps? Or?
A joint effort. There was a lot in academic literature that emerged in the early days of investment law discourse, but then it was indeed a joint effort because, as I say, if you look at some of the early seminal cases, Metalclad, TechMed, Occidental, and some of the Argentinian cases, then we see the articulation of that standard. Or even if we look at Saluka against Czech Republic, where one line in particular caught my attention. I remember saying that, well, investment treaties protect investors against governmental actions displaying a lower degree of inappropriateness. And justification for that is that, well, this would be good for everyone, not just for foreign investors, but also for society at large.
Wow, okay, that actually sheds a lot more light on this picture than I was previously aware of. So thank you for that. I want to turn from, I suppose, the general to the more specific, and look at the case of Latin America. And here I'd like to turn to Nicholas. So, how did the good governance argument, I suppose, manifest there, or how was it relevant there around this sort of this period of time that Mavlud is talking about? So, sort of the 90s and early 2000s. You could share with us.
Thanks, Caroline, and thanks for having me at SIEL as well. Yeah, so this is a great conversation. I'm very happy to be here. And as opposed to Mavluda, Logi, and Jonathan, I'm more like working on this as we speak. And indeed, yeah, I think if I would have to title the project, would be From the Calvo Doctrine to the Failure of Latin American Law. And particularly if we locate ourselves in the 1990s, I think there were many in Latin America who thought there was a need to lock in reforms. And I think the lock-in argument that actually, if you read the early UNCTAD investment reports, was highlighted. One of the reasons was why countries had to or were invited to sign these treaties was highlighted. For instance, in the case of Latin America, the main reformer and the person who launched the investment program of Latin America was the same person. And what you see is that when Latin America was proud of saying, you know, during the Calvo time and later on, that Latin American laws were good enough, so you didn't have to rely on foreign laws or foreign tribunals, there is a shift in the argument. There is a famous book by Jorge Esquiro that is called The Failure of Latin American Law, where he explains why many people in Latin America, from Latin America, were floating this argument. And he, in fact, connects the idea of investment treaties to the failure as one of the manifestations. So many people, I mean, I'm not saying foreign investors or international organizations, from within thought this was a good idea to lock in certain reforms that were passed in the 1990s. So I think there is some truth in that conversation. I know you wanted to talk about what was happening in the 1950s and so on. I think it was more like the reforms were being passed and the treaties were going to lock in those reforms. And this what shows is something that I find very interesting, is that it's not only international organizations of capital exporting countries selling investment treaties, but also there was a demand for a mechanism within this country. So there were certain people who were trying to make this happen in this particular way. And the interesting thing, and this is just, so there is a sort of transnational alliance of domestic elites and foreign investors, capital exporting countries, pushing for this project. And the interesting thing, I think, is you see how investment treaties have been used in the region, not so much in cases, but actually to sort of shut down major reforms. In the recent case of the attempt to reform the constitution in Chile, or actually to pass a new constitution, one of the arguments that was thrown was that you couldn't do that because of international economic agreements, especially investment treaties. And similarly, in the case of Colombia, with a major mining reform that would have changed completely the way we think about mining law and what areas of the country are open to mining or not, the main thing that was used by some actors within, I insist, this is domestic actors, within Colombia was investment treaties. So I think this lock-in argument has not been studied enough. And my intuition, and this is an intuition, is that it played out very importantly in Latin America during the 1990s. Thank you.
Thank you, Nicholas. Could I just ask you to elaborate? You talk about locking in, and my understanding is this was sort of locking in a certain, for example, you know, strong protection of property rights and so on. Is this the sorts of reforms you're talking about?
Yes, there is some of that, but there is other things. I don't want to just go too fast because I know Joseph is going to mention this and I'm going to explain how this actually, but there are other elements that are being locked in. It's not just the protection of property rights, but also the way governments operate, particularly in relation to certain sectors of the economy and what he was going to talk about, the centralizing power of investment treaties. But I don't want to go too fast here. Thanks.
Okay, great. Thank you so much. And so now we've sort of got a picture of how and why and in what ways this good governance narrative entered the investment regime. And so now we can ask, you know, do states participating in the investment regime indeed enjoy improved domestic governance, you know, for foreign investors, and also perhaps, as it sounds was promised, for also their populations and their communities. And so this takes us to the evidence, and several of our speakers' work on this issue has revealed a range of impacts. So I'd like to ask Joseph first. Your fairly recently published co-authored book, National Governance and Investment Treaties, and a related article, Investment Treaties and National Governance in India, shows that investment treaties don't sort of have a universal effect in shaping the state as a whole, but become tools that different ministries and agencies and actors within government use for different purposes, sometimes as a means of discipline and sometimes as a means of empowerment. I was wondering if you could explain your findings in that respect.
Sure. Thanks so much, and thanks, SIEL and Carolyn, for organizing this conversation and for inviting me. I'm really glad to be here with you all. First, I also want to note that I'm no longer academic in my day job, so I want to add the usual caveat that whatever I'm saying today reflects me speaking in personal capacity. So I think there's a couple of things to mention when we look at the idea of the state or the government that is being shaped by investment treaties that sort of underpins that good governance narrative that as it emerged, which Mavluda described. So because there's a couple of assumptions that are common to the proponents of this good governance narrative. And so the conception of a state that is fairly common to this literature is that the state is some sort of unitary black box, that it internally, there's black box governments, weighed all different options against each other in some sort of rational way before they act. And when they act, they also desire to comply with international obligations. And this is either because of the content of the international obligations or because of the remedial mechanisms of those international obligations. In this case, it would be ISDS arbitration. But probably to anyone who has ever worked for a government for a while, or in fact for any large enough organization or institution that is functionally divided, this idea of a government strikes probably as quite unrealistic. And this means that in reality, and this would not be a surprise to non-lawyers, political scientists and sociologists, governments and its institutions are a place of struggle. So institutions are entrusted with different mandates, sometimes conflicting mandates. One can think of Ministry of Trade and Investment versus Ministry of Trade versus Ministry of Finance, Agriculture, the Environment, or what have you. They are staffed with people that see world very differently. They have different mandates, different visions, and they also have different ambitions. And this is still at the sort of operational and technical level. Then if you add to it the elected officials, government's policies and programs, elections, civil society mobilizations, what it means is this: essentially the earlier accounts of good governance relied on this unrealistic way, but in reality, the institutional space where investment treaties intervene is rather messy. And it is not therefore that surprising that in this messy space, investment treaties will empower different actors with different interests within the state and public apparatus. And while in our work in the co-authored book you mentioned and in the article, there are important differences between the states that we have studied, there are certain emerging patterns across the states too. So first, it seems that lawyers get greatly empowered when lawyers within the state apparatus or within the public administration, that is, they are empowered. And it's especially lawyers with a particular outlook, with a sort of internationalist outlook, who are steeped in arbitration and international dispute settlement. And these lawyers are generally stationed at economic agencies, so Ministry of Finance, Economy, Trade, Investment, etc. So there's already this is slightly different to your generalist international lawyers and diplomats that would be stationed at Ministry of Foreign Affairs. That's not where these treaties seem to empower actors within the scope of within the space of national governance the most. And there's also a sort of dynamic of political geography that's a centralization to which Nicholas alluded to, and we see that specifically in larger federal states that the central agencies get particularly empowered to the detriment of government, the local governments, municipalities, and individual states. So all this means that if we take seriously the idea that governance is a site of struggle, different actors with different interests, projects, in agendas, and the claim that investment treaties improve national governance opens first a vast terrain of empirical research, but it also will lead to a situation where different actors will be using these treaties differently to different ends. So I think this is the main lesson of the focus on different governance actors within the state, rather than saying that the state as a whole improves. It's good governance.
Thanks. So it seems that, rather than, cause and effect, investment treaties cause good governance within the state. Any governance effects really depend heavily on which actors and agencies, institutions are involved, and I suppose the domestic political landscape. So those governance improvements, if you want to call them that, are contingent on a number of factors. With that, I want to turn to Jonathan, whose co-authored article, The Impact of Investment Treaties on Domestic Governance in Developing Countries, has revealed that in some states there doesn't seem to be any impact on governance at all, where those states have signed investment treaties. But before we sort of get to that, I'd like to ask Jonathan about what are the pathways or the mechanisms by which government officials may internalise investment treaty obligations? Need they necessarily know the content of their treaties, for example, or are there sort of more diffuse ways in which investment treaties exert, if you like, sort of discipline within governments who are party to those treaties? And then what has happened in states that you've studied, such as Myanmar, where it seems that officials that you, from your study, barely have any knowledge at all of their country's investment treaties?
Yeah, thanks, Caroline. And this is a great question because, you know, on this call, I've learned so much from other people working in this field. And I really think this picks up something that both Nicholas and Joseph have already drawn attention to. And I think we'll also hear from Lauga and Mevluda probably as well. But the basic thing, the first thing we need to do is get away from this idea that the state is a unitary single actor or a black box. So that's got to go. It's not helpful. But the next step for me to sort of answer the question about the mechanisms or pathways by which investment treaties can have impacts on governance, and here governance impacts for better or for worse, is to sort of try and, I guess, set out a basic categorization of some of the different ways they could have those impacts. I think that's quite helpful in thinking about these questions, and it's something that we tried to do in this article. So at the probably simplest or most intuitive level, investment treaties can have governance impacts through internalization measures, like government officials might be trained in investment treaties. So they learn about them, and the idea is that they're meant to then act in ways that are more consistent with the treaties in their day-to-day work, or they might be given a handbook to explain to them what investment treaties mean and how that might relate to their work. Or perhaps investment treaties are integrated into existing compliance review processes. So we can have these basic set of internalization mechanisms by which investment treaties can influence governance. But then there are sort of stepping out at one level more broadly, investment treaties could, at least in principle, have impacts on institutional structure and the legislative apparatus. So Joseph has already drawn attention to this. They might empower some agencies relative to others. Investment treaties could be reflected in national legislation, and then if that were the case, then government officials might end up applying the national legislation. Investment treaties still have an effect in that context, potentially, but without necessarily the government officials who apply the national legislation being aware of the treaty itself. Or there could be other forms of institutionalization, for example, the establishment of foreign investment grievance mechanisms or investment dispute prevention agencies. So then the third category, sort of opening the aperture even wider, is that investment treaties could at least reorient the entire way that government officials conceptualize foreign investment as a field of regulation, the sort of conceptual map that they carry around in their head, the way they think about these sort of problems. It's something that I think relates to some of the work that Nicholas has done in a different context about the legal imagination. So these kind of discursive and cognitive effects, they're quite hard to observe directly, but that doesn't mean they're not important. And so one way when we're doing empirical work is we can get down at the level of the government officials, and when we're doing sort of field work or interviews, seeing if government officials analyze problems or frame them through the conceptual language of investment treaties, that would suggest that investment treaties are having these diffuse effects if government officials are thinking about the importance of treating foreign investors fairly and equitably rather than thinking about, say, cost-benefit analysis. And finally, even if investment treaties don't have any of these effects on domestic governance, it's still possible that a foreign investor can walk into the Myanmar Investment Commission one day and say, unless you change this regulation, I'm going to bring a case to ISDS. So these kind of bargaining or threat-based dynamics, if government officials then change the way they act in response to these kind of interactions, are another pathway that investment treaties can affect governance. So circling back to the sort of core of the question that you asked about knowledge, how much knowledge do government officials have of investment treaties? I guess one thing about setting out those different mechanisms is that not all of them necessarily depend on government officials themselves having direct knowledge of the treaties. But very few in my empirical work over several years in Myanmar, there is actually a very high level of knowledge of investment treaties, but among a very small group of government officials. And that knowledge doesn't really diffuse beyond those few government officials, even to the extent that we have these great anecdotes of entire legislative reforms being worked up in the same government agency on a different floor in the same building that are probably non-compliant with investment treaties, and the even fact that there is a treaty issue here is never even identified. So the knowledge of investment treaties exists within a very small number of officials. It's not institutionalized across the state apparatus. And why might that be the case? Well, even in Australia, where I've also worked in government, governance is complicated. People are busy, resources are constrained, there's lots of priorities, investment treaties are not the most important thing. And in a country like Myanmar, which is severely resource constrained, all of that is much more so. But at an even deeper level, two of the problems of lack of institutionalization and lack of knowledge relate to the fact, firstly, that investment treaties don't map easily onto the state apparatus. They're not addressed to a single decision maker. They're potentially addressed to all government officials who interact in any way with investment. Okay, so that's one challenge. And the second one is it's not clear what those officials actually need to do to comply with the treaty. It's not like a tariff or revising a negative list. The actual content of an obligation like fair and equitable treaty is fair and equitable treatment is quite abstract and unclear. So these kind of characteristics of the treaties themselves are very serious barriers to governance effects and institutionalization in developing countries.
Great. Oh, thank you both. That was a really sort of rich, amount of evidence that you've gathered that shows this real, I suppose, variegated levels of internalization, institutionalization, and but overall, this idea that investment treaties, have a uniformly salutary effect on all governments throughout the world, and every agent within those governments, certainly, has a rather shaky evidential foundation. Jonathan, you raised and Joseph both sort of hinted at some points that I'd like to explore further with Mavluda and with Nicholas, in terms of, so to the extent to which investment treaty participation does result in improvements in governance, or sorry about the inverted commas, in good governance, in whose interests is this good governance? So good governance in the service of whom? So I'd like to start with Mavluda, and I'm thinking about your book, your excellent book, Impact of Investment Treaty Law on Host States, Enabling Good Governance, ? That argues that the forms of governance that are engendered by investment treaties, in fact, reinforce or aim to prioritise investors' interests, as opposed to governance, in service of the domestic population and local communities. And then your more recent piece in AGIL Unbound, which is about investor-state dispute prevention mechanisms. So I don't think I have that quite right. Investor-state, DPMs, sort of takes this further and says that this sort of thing, and picking up on what Jonathan said, they reinforce, this idea of legal enclaves for investors. I was wondering if you could speak to sort of the general point, which is good governance for whom, and then perhaps elaborate a bit with reference to this most recent development with dispute prevention.
Thank you, Cameron. So yes, I mean, dispute prevention agenda may not look as there may not be an obvious connection with what we're talking about, good governance. But I remember, and I think that actually I found similar conclusions in other empirical studies pointing to similar developments is that when I went through those interviews and empirical case studies, one thing that I've noticed that in a number of countries in my case study, there were at least some discussions of dispute prevention mechanisms. And the idea is that the link between dispute prevention and good governance is effectively for the governments, for developing country governments in particular, to apprehend their own bad behavior, sort of to intervene earlier on before investor-state grievances escalate into investor-state disputes and then lead to potentially painful monetary consequences for the government. And so the idea is that if there were to be a certain governmental agency that would centralize government decision-making and deal with those investor grievances earlier on and effectively, then there would be no investor-state disputes, and then governance would improve and everyone would be happy, investors, host states, and their communities. And then we see the resurgence of that narrative in recent reform proposals, including the Answer Trial Working Group 3, but even before that, the World Bank's proposal on the so-called STIRM mechanism, which is essentially a variety of a DPM, and the mechanism that proposes the creation of a centralized agency that should intervene. And what struck me in those proposals is that it is very often the idea is to resolve those investor-state grievances through any means possible, including by resorting to political solutions lying outside the law, and that the ultimate aim is to satisfy foreign investors. And then that then dovetails with various criticisms that we've heard from the early days of investment treaty regime, that it does prioritize or over-prioritize foreign investor interests. So essentially what we see then with DPMs and with other good governance manifestations more broadly is that it is good governance primarily for foreign investors. And there's well, very limited, if any, empirical evidence to suggest that there would be good governance improvements for any other stakeholders outside foreign investors.
Thank you. I want to turn to Nicholas now, whose work also calls attention to those who benefit from and those who are silenced by, the way in which investment treaties can reorder or reorient governance. Now, Nicholas, a co-authored work in progress that you've shared with me and the rest of the panel examines investment treaties' role in extractivism, focusing on Latin America, and also makes the, surprising to me anyway, the connection between Latin American countries' constitutions as well, and sees them sort of working synergistically together to secure resource extraction, with the effect of suppressing local communities who are impacted by these activities. Would you be able to tell us more about this research and what it might tell us about investment treaties' role in fostering good governance and for whom?
Yeah, thank you, Caroline. Exactly. Yeah, I was thinking about your question about, who wins. And normally, or at least when I started reading about like international investment, there was like this sort of, public v private power discussion, constitutions, domestic law against, investment treaties, investors against sovereign powers. And I actually was surprised to read my friends who do a constitutional law in Latin America complain about constitutions precisely more or less in the same way we complain about investment treaties, that they are extractivist, that they're empowered central agencies, that they displace local communities, saying, wait a second, what's going on here? Like they're doing the same thing. So actually more like, one being imposed on the other, what I suggest in this paper, that as I said is work in progress with two colleagues, there is more of a symbiotic relationship, a bit of a reinforcing situation, a division of labor, if you want to. So very briefly and schematically, if you look what constitutions do to favor extractivism, they turn nature into natural resources. They ensure those resources are allocated to the central state normally, and that the central state has the authority to grant concessions or contracts, many of them to foreign investors. And to do that, you need to displace surface owners. And it might also be the case that they're displacing local communities, indigenous peoples. So no, most of the time, the mining ministries, they are centralized authorities. They have authority over the whole country. And then in addition to that, yes, you protect those rights that are being created, the resulting rights. What is interesting is that constitution and the constitutional mechanism not only protect individual property rights, but it also protect the competencies of federal, national governments over those resources in case there is a clash with regional local governments. So, I mean, of course, constitutions do provide space for progressive reforms, the social function of property, the rights of the environment, of nature, sometimes now in Latin America, environmental rights, environmental protection. But there is a sort of extractivist way we think constitution, or some people expect constitutions to operate in that sort of mode. So a very famous Latin American constitutional lawyer whose name is Roberto Gargarella, he says that even if we had like these very major reforms in some constitutions, even the most progressive ones, they keep the sort of, centralized way in which the government operates, the centralizing power of the government. And that is sort of the way in which we kind of, keep reproducing certain modes of, capital accumulation, like extractivism. So what I see now, if you take that picture, is that investment treaties sort of reinforce certain of these trends or tendencies. Of course, they provide additional protection to property rights, but something that we have not paid that much attention is that they also reinforce the centralization of power. And there are certain actors within countries in Latin America that want that to happen. I mean, I'm not only talking about, like the domestic elites, even people who favor certain way of which these countries are organized, like, like unilateral, not unilateral, sorry, that is, instead of that, they're opposed federalism, they're opposed giving additional powers to regional and local governments. So in that story, I think investment treaties are operating slightly in a different way, which we normally think. I just to conclude, I find very interesting, there is a piece by Bro and Kavanaugh where they claim that one of the reasons why it was possible to pass generally broad mining bans in Salvador and Costa Rica is because the domestic elites in those countries were not interested into extractivism as other elites in Latin America. So the ISDS threat in those countries was less powerful, not because ISDS operate differently in those countries, because the domestic elites didn't care that much about those specific sectors. So I think that then it's not so much one is on top of the other, but how much they operate in different settings at the same level sometimes. And this is something I'm working on. To me, it's puzzling, as in it's different from what I imagine it to be 10, 15 years ago.
Thank you for that. We really look forward to reading that piece and to seeing the symbiosis, which as I said, was a surprise. And thank you also for bringing in the interest not only of foreign investors but also of domestic elites and certain sort of high-level political central government who don't want any kind of subsidiary power being exercised at regional levels. I want to turn now back to Joseph, because what Mavluda and Nicholas have said about governance being reshaped around investor interests and then perhaps also certain domestic elite interests. Do your findings, Joseph, also suggest that these bureaucratic power shifts that you've talked about tend to ultimately end up reinforcing, governances that is sort of oriented toward the interests of investors, or have you found that there is within those states some bureaucratic resistance or contestation, in that direction?
Yeah. Thanks for this question. I think that what we found in those publications is that overall that treaties do tend to reinforce this investor-oriented governance. They tend to foster creation of legal enclaves and special preferential regimes rather than sort of trickle down to the benefit of all. So in this sense, I could definitely align behind Mavluda's and Nicholas's work. But Before I get to the resistance question, I would like to highlight two other aspects that I think are important. First, I think Mavluda's work in particular highlighted that the internationalization of investment treaties leads to this creation of legal enclaves and special regimes. And in our work, we have found that happening too. And we also have this from the critical perspective of a discussion about the regulatory chill. I think that is important to note also that investment treaties facilitate regulation as well. And it's precisely the regulation that creates these kind of special regimes, be it special economic zones or be it specific longer terms before a regulation kicks in to allow investors to arrange their finances, etc. So essentially, this is a flip side of the regulatory chill that investment treaties do foster or contribute to the creation of special regulatory regimes, which is not necessarily a regulatory chill, but rather facilitation. But I think that these moves to create these investor-centered regimes are not always done because the governments, the elites think that this is the best thing to do, but it is also because sometimes it is a resource question. And Jonathan highlighted the resource question in his intervention. Sometimes it is, especially for developing and emerging economies, it is simply cheaper, at least in short term and long term, to just accommodate for an investor's demands than to improve and enact a coherent governance reform that would benefit all of the population. So this is one thing what I would like to highlight. And the second one, and I think this gets also to the resistance question, is that when we discuss the empowerment of investors and on that sort of stylized axis between the government on the one side and investor on the other side, we might miss also the improvement of the relative position of other actors. Nicholas mentioned the local elites, but there's also the empowerment of what I would call the arbitration industry. By that, I do not mean only lawyers and private firms that are specialized in arbitration, arbitral institutions, but this broader machinery that straddles that divide between the public and private sectors, this loose coalition of that are united in their common institutional interest in the continued viability of international adjudication as mode of governance. And they can be from, of course, from a law firm or an arbitral institution, but they can be from a ministry defending the states. They can be an academic. They can be indeed an in-house counsel of foreign corporation. And I think that they are the interest group that have been empowered the most by these treaties. And they are not always investors. And I think that is important to highlight that. And there is, in our work, we've seen this interesting paradox emerge, especially when it comes to dealing with investor-state disputes at the national governance level. An ideal situation for a state that has investment treaties with ISDS is to have no ISDS, or at least a very limited number of ISDS cases at any given time. But in case such case comes, you would want to be able to deal with these cases through in-house capacity to defend them without resorting to external private legal counsel. But to build and keep such a capacity, that is, of course, costly. So once you build at the state level, once you learn from the painful growing pains of defending your first ISDS cases, you manage to build that in-house capacity. You essentially end up in the situation that you have these bureaucrats. They are specialized in ISDS and international dispute settlement, and they either want to keep working for the state and to deploy their expertise, but for that you need ISDS cases. But if the ideal situation is no ISDS cases, there you can see already a tension. Or you retrain them, but that requires other additional resources and have to have motivation to switch to something else, or you leave to private practice so you can actually economize on the built-in expertise. So I think that investment treaties contribute to the creation of this ecosystem in which promotion of dispute settlement work actually becomes an end in itself. So in a very roundabout way to respond to the question about resistance, yes, there's indeed spaces of resistance, and many actors have been mobilizing counter narratives or unsettling this investor-centered law. But I think it's important to when thinking about resistance to investor-centered law is that it is probably, as a question of tactic, it should not be only about investors versus state, because the foreign investors are not the main beneficiaries, I would say, of the regime created by ISDS, even if the treaties, of course, improved their lot. The arbitration industry is probably the one that has benefited the most.
Thank you. And, that's, I think, important, important distinction between sort of, the popular kind of, I suppose, take on this. And we'll return to that when we sort of have another round of observations. But what I want to do now is turn our focus to capital exporting states, the original architects of the regime. Because based on what we heard today, it seems that the idea of investment treaties as enabling good governance was always aimed at disciplining developing countries. But was there a suggestion that they also served this purpose within capital exporting countries? And here I'd like to turn to Lauga, who's working on a paper that demonstrates that at the same time as that it was sort of pursuing, advocating for full market value compensation for expropriations for its investors abroad, the UK government, in fact, had not internalised its own, in fact, its purportedly universal international standard, because at home it was engaging in less than fully compensated expropriations. And so this sort of begs the question, well, if capital exporting states didn't apply the standards they demanded abroad, can the good governance justification be taken seriously? So could you tell us more about this and what your research has revealed, and then perhaps reflect about what it tells us about the credibility of the good governance justification for the regime?
Sure, Caroline. Just in the interest of time, I might just sort of sketch what I found, and maybe we can leave sort of the broader reflections to the discussion if there's an appetite. Yeah, so there's it's a large archival project of a capital exporting state's own expropriation policy during the Cold War, and how it reflected on whether and to what extent that policy and those measures were in fact aligned with the international standard on compensation. And so I focus on the large-scale expropriations in the UK in the 1940s and in the 1970s, specifically the North Sea, but also other takings in the 1970s. So these are early expropriations, many of them before the onset of investment treaties, but the question was around the core standard of sort of prompt, adequate, and effective compensation, which is now, of course, also included in the investment treaty regime. And the expropriations in the 1970s was exactly at the same time as the UK was starting to negotiate investment treaties itself. And as you alluded to, time and again, we find in the archives that the UK, specifically the Foreign Office, noted very explicitly that British expropriations at home did not come with full compensation quite frequently, despite asking developing countries in individual disputes and treaty negotiations for full compensation, right? And there was this sort of fundamental conflict that was being discussed and assessed within Whitehall from the 1940s onwards that I think speaks to our discussion today, because the UK was not willing to give at home what it was asking for abroad. That's quite clear, and officials themselves acknowledge that. So to just give you a couple of sort of fat quotes from the archives, right? So in the 1940s, a senior Foreign Office official, upon reflecting on the UK's own policy abroad and its policy at home, concluded that it was a, quote, thoroughly ad hoc and opportunist approach. Later, in the Anglo case in Iran, the Foreign Office again noted that it would be quite difficult to explain to the Iranians why the UK paid very limited compensation, for instance, in the case of coal at home, while insisting on a different standard for oil in Iran. In the 1970s, the Energy Department, which was leading on the North Sea expropriations at the time, or renegotiations at the time, said, in the past, when we've talked about prompt, adequate, and effective compensation, we've normally meant the market value of the rights expropriated. We believe that is out of the question that we, the UK, should pay at this level in the context of the North Sea. And of course they didn't, right? And in ongoing UN discussions around the same time, UK officials also noted internally that it looked quite awkward that the government was pursuing a, quote, double standard when it comes to paying compensation in our own backyard. So what you had, I think, up through the Cold War was you had a number of legal officials, specifically in the Foreign Office, that did sort of themselves internalize, reflect on the commitments, but shifting governments nevertheless ultimately decided that the international law standard on compensation should not restrict their own expropriation policy in any meaningful way. So insofar as the international law standard was about governance, it was a governance model that the UK, for its part, did not want to implement at home, right? So when assessing the good governance narrative, I think sort of just on a research note, I think it might be useful or interesting to start having a closer look, maybe a more systematic look at whether developed states have in fact done at home what they're also expecting abroad. And that could be, I think, a useful complement to much of the really valuable sort of literature and research that's been undertaken in this field so far, including by the panelists here today. Thank you.
Maybe another PhD project or several. Okay, yeah, thank you so much. That really, I think, completes our sort of exploration into this fascinating topic. I want to allow lots of time for Q&A, so please, if you're online, please put your questions in the Q&A box. But before we do so, what I'd like to do is invite each of our speakers to offer one sort of wrap-up, sort of semi-final reflection. If you can, I'd encourage you to identify a point of difference or tension or an unresolved issue, perhaps whether in method, normative assessment, although I think, you think fairly similarly, or how one conceptualizes governance in this context. In other words, where are the disagreements still in this conversation? And what needs to be interrogated further. So Laga, you've already offered a great suggestion on what should be sort of next on the research agenda. I'd like to hear from the others as well. And after these observations, we'll open up for questions from the audience. Laga, while you have the floor, I'll go back to you first for any kind of concluding or semi-final observations you might have, having heard from everyone this morning.
Well, I don't really have much more than what I already mentioned, except for maybe one general observation. That is sort of as a reader and consumer of this literature, I think the conversations we're having today and these sorts of topics are, to some extent, by far the most interesting. I mean, really by far the most interesting within the literature on this regime. And so I guess I would just encourage more work here because there's a lot of low-hanging fruit. And we've heard several ideas today. I really sort of the work that Joseph mentioned, for instance, on what happens when we start training officials and engaging officials on investment treaties, what happens to them after that fact within a government when they're sitting there without a case, advising also on policy, just strikes me as a fascinating and obviously very important question because I'm sure everyone on this panel have we sort of know what Joseph is talking about. We know who these people are and what they're doing and what they're saying. But I think documenting that empirically strikes me as a really, really important research project.
Absolutely, yeah. It calls to mind all sorts of parallels, in other areas. So I'd like to turn now next to Mavluda, please.
Building on what Lauga just said, but also contributions of other co-panelists, I've been thinking along similar lines. So first of all, what is the meaning of good governance? It is yet to be studied properly. Say, if we go back to the point that Jonathan made about the knowledge being concentrated within very small group of government officials and not necessarily being diffused or cascaded down, a more longitudinal study would be very interesting, especially at this juncture and maybe even later, to see that whether 4 or 5 decades into the functioning of investment treaty regimes, whether things actually change, whether we see different patterns of diffusion, whether diffusion actually happens, and what effects it might have. Then also on the method, it also occurred to me, listening to my co-panelists and trying to locate everything and connect it within the broader literature, that Lauga's work on focal points brings to mind the importance of combining not only empirical studies of the kind that myself and a number of colleagues here have engaged, case studies, interviews, but also trawling through archives to look at what were the original intentions behind investment treaties and other forms of investment protection that we see in international legislation or elsewhere. So those would be my 2 overarching points.
Thank you. And can I call now on Nicola?
Yes, thanks, Caroline. First, I really enjoyed this conversation. So I echo what Logan said. I mean, enjoy everybody's work here. So it's been great. So, or more like of a sort of a general note of the discussion, I would probably say that one thing that it kind of keeps coming to my mind is that we see how different actors are trying to, isolate or protect certain spaces. So the question of how we separate the market from politics is very interesting here. And as we see in the trade area, that the two things are being re-emerged or put back together. There is a sort of politicization moment of international economic law. We lived during a depoliticization moment. So all the tools, the different mechanisms that are used to do one thing or the other, I think it's very relevant for us to kind of make a list, and see how they've been deployed, used by different actors. That's one thing. On the future, I mean, I'm being based in the global south. I'm always sad that there are no really good archives in the global south. That is very difficult to understand why countries signed the treaties. We normally have the sort of the view of international institutions and what they made of the global south, but it's much more complicated to get a very detailed view here. And particularly one of the things that bothers me the most is this sort of basic assumption that nobody knew what people were signing in the 1990s. I mean, Logan just mentioned the practice of the UK, but if you look at the literature from the 60s, 70s, 90s, the idea that nobody knew, I think, is a bit far-fetched. I think that a lot of people, many, not a lot, but at least a few people knew what they were signing into. And once you add that into the conversation, I wonder what comes out of that. What if some people knew what they were doing? And I'll leave it there. Thank you.
Thank you. Joseph, have you got any further words?
Yeah, I'll also echo that this has been a great discussion. So thanks so much. And I think many topics have been mentioned already. But if there's one for further research, which I think that would be I would double down on the role of dispute settlement industry. And I think that in a way it continues. I mean, Nicola's historical work and Lauga's work on the Norman entrepreneurs of the regime from the past. I think that there is with the emergence of international dispute settlement as industry from the last 25 years, I think that the sort of movers and shakers within the regime are slightly different that they were in the past, the isolated individuals who might have known and the global south or a couple of people in the global south in different countries. I think that it also goes down to the point made by Jono that now there is more knowledge and awareness of that, but it's of course difficult thing to empirically study that awareness and how far it goes within the governance sphere. But I think that just the presence and within we could just look at working group 3 at UNCITRAL, right, to see the role of dispute settlement lawyers, which is something very different than if we look at the negotiation history of the Exit Convention, for instance, right? Yeah, I think that the role of dispute settlement lawyers, counsel, beyond arbitrators, but I mean lawyers who represent states and the government, I think that's something that is worth exploring further in this.
Thank you. Jonathan, would you like to pick up on that? Perhaps also with reference to Working Group 3, which I know you've been following closely in your role.
Yeah, I guess it does relate to Working Group 3, but I was going to, on a question for research, emphasize more the role of foreign advisors, which can overlap to some extent with the role of lawyers. I mean, I've been a foreign advisor. I imagine many of the people on the call in different capacities have been advisors, but this field, for example, one thing really striking in Myanmar at some point was that a group of foreign advisors funded through the World Bank turned up with a new draft for a new national investment law, which was just cut and pasted from an investment treaty. So that doesn't really make sense at all as a national investment law. It's a completely different type of instrument. It shouldn't look like a treaty. But thinking about the way that investment treaties as a field of knowledge then reshape the practices of investment governance more broadly through foreign advisory work as a vector, but also how that's resisted, I think is a really interesting research project. And just on, you asked us to emphasize points of difference. I mean, just to avoid the sense that we all kind of singing from the same song sheet, although I think there's a huge amount of common ground here. I do think one of the things that's interesting compared to some of the other work, Nicholas and Joseph's work in particular, and my work, is that we probably came up with a sense that investment treaties were more peripheral. I mean, they still matter in some way. It's still interesting. You still have these enclave dynamics, but the sense in our work was that investment treaties are more peripheral to practices of investment governance than the picture you might get from reading Nicholas and Joseph's work. And I think, that's one of the beauties of empirical work, because we're studying different countries in different periods. So it's quite possible that what we're seeing is different stories play out in different places. And if that's the case, then there's a really interesting set of questions here about sort of understanding some of those differences. Obviously, Latin America has got a particular history here that is different to some other regions of the world. And so I think that's a really interesting discussion to have as well.
Thank you all for those comments. We'll now turn to the Q&A, and I can see we've got a few questions here. Keep them coming. The first question is for Nicholas specifically, and the asker of the question, if that's the right word, says that the locking ineffective investment treaties that you were talking about. The question says, so do you think that given the indeterminacy and abstraction of investment treaties, and John was talking about this, I think the locking in effect can be ameliorated or made more flexible through interpretation and reform in terms of allowing more flexibility for how governments operate? Or, and this points to some of the questions that I'll ask next, because I can see a bit of a theme emerging here, is the system itself incapable of accommodating change?
Yeah, thanks. And thanks, Clara, for the question, because it allows me to clarify something. One of the things we do in the paper that, I mean, for reasons of time, I did not discuss here, is that I think it's important to separate the effects of investment treaties from a sort of more systemic lock-in effect from the specific cases. So when there is a case, of course, what I've seen, and I'd be interested to know knowing what other people think about this, but what I see is that the government normally aligns within the interests of that particular state when there is a case, when the case hits. But before that, I think investment treaties are used in a way that is not so much about the specific interpretation that is given in an award, but it's more like a certain use. So maybe the way domestic elites use investment treaties to try to block a reform or to chill a regulation is different from the way arbitrators use it in a treaty. Sorry, in a case, and eventually or ultimately in an award. So I mean, so of course there is a connection between the two things, but what I see domestically, it's not so precise. So actually that level of flexibility is probably on purpose there. And I mean, we could go back to the 1950s and why they wanted to keep it flexible, but that would take us too long. I think so the question is not so much whether we can work better on the particular interpretations, but what we think the best regime to protect investors or to govern international investment should be, as opposed to about changing one clause or the other. Because by the way, we know from constitutional property law that it's not about changing a regulation or a provision. You can have very different interpretations within the same text. So I'm not sure it's about working with the text, but more about sort of institutional reform.
Thank you. Now, there's a bunch of questions that sort of speak to various aspects of a similar theme. The first couple of questions, I'll try and combine it and pose to all of our panelists. What do we think about the project of reforming investment treaties, project reform? Is this ever going to, if you like, appropriately, sorry, it's a terrible word. Is it ever going to rebalance, shall we say, the regime that, more in the interests of the populations of capital importing states, or do we need an entirely different mechanism or mechanisms to regulate and govern foreign investment? So it's a really fundamental question, of course, facing the regime. And so several participants have sort of posed this variations on this general question. So I would like to open it up to anyone who'd like to jump in on this.
May I start?
Go for it.
So I think that a lot of these discussion, basically the discussion that we had today was about investment treaties with investment protection standard in ISDS standards and ISDS, investment treaty arbitration as dispute settlement to enforce them. This is, of course, probably whenever you speak to someone about investment treaties, this is what they imagine, right? However, I think it is important to note that investment treaties may do other things than protect foreign investors and provide open access to advance access and consent to investor-state arbitration. And we already see that there is different things what we can do on investment in different states. Have Brazil being one example that highlights facilitation and dispute prevention. Regardless of the merits and demerits of this particular model, what I want to say is that when the question is posed whether to abandon this regime or whether abandon investment treaties, I think it is important to know what do we mean when we say abandoning investment treaties. Are we talking about removing investment protection and investment treaty arbitration, or are we just saying that foreign investment or investment should not be regulated through treaties, period? I think there's many things that can usefully be done through treaties to regulate investment and to address some of the points that Lauge and Jonah mentioned in the beginning of the conversation about improving the developmental impacts of investment treaties, minimizing negative impacts and negative externalities from investment projects while maximizing the other ones, creating mechanisms of cooperation on investment, regulatory cooperation, etc., investment facilitation, what have you. So there's many other things that investment treaties can do that are not about investment protection and arbitration. And I think that is important to note when we discuss the question about reform. So I'll probably keep it at that for the moment.
Thank you, Jonathan. And Jonathan, when you speak, I was wondering if you could remind us about that statistic of how much investment abroad is actually regulated by investment treaties, because as I understand it, it's a fairly low figure. What might that tell us about the need for these treaties?
Oh, yeah. I haven't prepared it off the top of my head, but I believe that I think the OECD has an infographic on this, that there's about 2,500 bilateral pairs of country relationships that are covered by investment treaties. And if we think of the number of countries in the world and the number of pairwise relationships, I think there's about 18,000. I think that's right, maybe 15 to 18,000. So in any case, it's only a significant minority, but a minority of pairwise bilateral relationships that are covered by investment treaties. And if we think about some of the world's biggest foreign investment relationships, the relationships within the EU, the relationship between EU countries and the US, the relationship between the US and the UK, the relationship between the US and China, many of these really big bilateral investment relationships are not covered by investment treaties either. So whether you do it by numbers or by the fraction of global investment stocks, either way, the picture that emerges is that the investment treaty regime is really a minority regime. And that's an important perspective just to remind us, if people ask the question, what would it look like to have a world without investment treaties? Well, the answer is that most of the world operates without investment treaties most of the time. Doesn't mean it's a good thing. It's just a really important point of reference. But on the question of what this, I think people know my views about investment treaties. But I answer a slightly more precise question maybe, which is what the good governance research or the research on the impacts of investment treaties on domestic governance can tell us in thinking about reform of investment treaties. It's a slightly more precise question, but an important one. So one thing that comes out of our sort of work in Myanmar is that it's very clear that there's no mechanism within the state apparatus by which very finely graduated adjustments in treaty language are then translated down to fine-grained adjustments in governance effects. The treaties just aren't having those sorts of impacts. So that actually tells us something important about reform, because it says if we think there are problems with the treaties, those problems aren't going to be solved by fine-grained adjustments to treaty language, clarifications of what fair and equitable treatment means at the margins, slightly more tailored exception clauses. It's not going to do the work because that's just not how the treaties are operating on the ground. So that's one really important implication in my view. And another really interesting insight that goes to Joseph's point is one of the few areas in Myanmar we did find that there was a better understanding of treaties' impacts related to investment liberalization commitments. So that was one of the very few areas where there was a concrete understanding in government that the commitments meant something and that they had implications for how the economy was regulated domestically. So I'm not necessarily advocating in favor of binding market access or liberalization commitments in investment treaties, but it's a really important point of reference in that debate to understand that while the investment protection provisions in treaties may not have particularly clear or fine-grained governance effects, that quite different types of provisions might actually have much more concrete effects, perhaps because they're understood more clearly by government actors and are much more clearly addressed to specific regulatory levers that can then be changed.
Thank you. Do any of our other speakers want to jump in here? I'll move to the next question. So there are a couple of questions that speak to, the sort of the imbalance of power that we're all very familiar with, within the demandeurs of the rules and those who sort of acquiesce to them. And one question sort of picks up on Lauge's point about capital exporting countries not following the standards that they demanded, and then suggests that within UNCITRAL Working Group 3, powerful countries have I suppose, I'm not going to say what was said here. The more powerful countries, exert a greater influence over those negotiations. Vis-a-vis the less sort of bureaucratically well-equipped states, at the table. And if this is the case, then do you think any reforms under Working Group 3 would really basically reinscribe that same result as investment treaties? So the asking people to adopt those sort of norms and standards in other countries that the country demanding them doesn't necessarily do at home. And so this isn't just a question for Lauge, it's a question for everyone to reflect on, as this sort of continued power disparity within sort of negotiations to reform the regime.
I guess I can start. I mean, first of all, by saying that I cannot answer that question for several reasons. One reason being that I'm still chair of OECD's work on investment treaties, as of the future of investment treaties, and so obviously, for obvious reasons, I can't sort of really speak to ongoing policy debates, at least not in this forum. But I think there are maybe two interesting observations here, also from a research perspective, and that's the role of power. That's sort of being alluded to here. And the first observation, I guess, goes back to Nicholas' point from before, which I think is really, really important to try and understand the conditions under which understanding the commitments that were being entered into at different points in time by different jurisdictions and the role of, I think, different relationships between governments existed. To document that is really very, very difficult particular given that we don't have sort of good archival sources on the developing countryside. But that doesn't mean that work shouldn't try to be done. I think the work that has been done on this suggests that there was a much closer engagement with the commitments in the 60s and 70s than for at least some, not all, but some developing countries during the 1990s. I, a couple of months ago, managed to actually find the Pakistani files on the very first BIT. So I dug them out of an archive in Islamabad, where there is quite a lot of discussion around what was understood by the Pakistani government at the time and what was the role of power vis-a-vis Germany in 1959. And I think there's tons of work to be done, also alluding on what Nicholas was saying, that hasn't been done yet, but it's just beyond our policy debates, just fascinating research that could be done on a case, on sort of on country by country basis, region by region basis, where power really should be taken very seriously as a sort of focus of study in terms of how it drove the regime in different ways in different contexts. And I think, speaking to the question more specifically, I think another important sort of more current research agenda could be what's happened over the last sort of 10, 15 years with the regime and where is it heading? Because I think if you take a big step back, at least to me, what seems to be happening is we're moving back to a North-South regime. Many developed states, OECD states, the EU, the United States, Australia have so far tried to step out of liability by removing themselves from treaty relationships where they're exposed. We've seen that with intra-EU BATs. We've seen that with the Energy Charter Treaty. We've seen that with renegotiating NAFTA. We've seen that with stopping, including ISDS, in North-North agreements, while keeping in place sort of traditional North-South treaties. So I think something structurally really, really important is happening that hasn't actually been taken that seriously in the research, because I think something has happened over the last 15 years that makes the regime look quite different in terms of distributional liability potentially than when some of these discussions started in the research literature. I think so. I think the role of power and how it manifests itself in the regime could be a really, really important discussion, not just from a policy perspective, as the participant would like us to speak about, but also from a research perspective.
Thanks very much. Nicholas.
Yeah, very briefly, I think there is also a meta question on Loge's question, research question, which is that the avalanche of investment treaty scholarships started when scholars based in the global north were concerned about awards against them. And then what will happen once we go back to a situation where most awards are against global south countries? I mean, as you probably all know, most of the sort of civil society action is basically within Europe. What will happen once the cases are not against European countries? I think that's also, I mean, it's a meta question, but I'm also like looking to see what's going to happen on that way. Yeah.
Yes, yeah, that's a really great point. Did anyone else want to respond to that? We have probably time if anyone wants to post any last minute questions. I have a question that asks us to think about developments in the trade regime and what that might say to the investment regime. So the question talks about, I suppose, the demise of the multilateral trading system and mentions a particular government's disregard for international trade rules. You can probably guess which one. And asks, what implications does this have for how we understand and engage with the investment treaty regime? So, fascinating question. If anyone would like to start us off. Ooh, tricky one.
Very quickly, and it's not going to be my own words. It's going to be the words of Stefan Schill, that you all know very well. And I remember Stefan once presenting about investment treaties, and a similar question was asked. And he provided a very interesting response. He said that, look, one of the advantages of the spaghetti bowl of investment treaties is that it's very decentralized and diffuse nature, means that there is a lot of stability to the regime. in a way that is not the case with the WTO, for example. So if you derail the operation of the appellate body or other vital mechanisms within WTO institutional structure and law, then the entire thing may come to a halt. Whereas with investment treaties, say in a hypothetical case of the United States withdrawing from the regime, we would still have a lot of bilateral investment treaties that remain binding on various countries, and that is one thing that is probably both good and bad, and depending on what angle you're looking from, and yeah, so
Thank you. Thanks. Does anyone else want to add to that before I go to what will probably be our last question? This one also mentions the US as well. But it picks up on Jonathan's point about foreign advisors, training officials and developer capital importing states on investment law, and Nicolas' work on norm entrepreneurs. How do you see current geopolitical shifts, including the shutdown of US aid, impacting the future of the regime? And I think by this, the questioner is asking whether there's going to be, no more technical assistance, no more sort of capacity development, and what might happen in that instance, if I understand correctly. But you both would understand better than me. Jonathan, as a former foreign advisor, do you want to jump in?
Oh, it's a really good question, and I honestly don't know the answer to that. My sense is that the US government has been a funder of some of that work in the past, but I wouldn't be able to say how much of that has come through US aid or what fraction of it. I'd recommend, if you're interested in this line of work, Taylor St. John and Tara Berger wrote a fantastic paper on the role of the IFC's advisory work on national investment laws, including recommendations to put ISDS provisions into those investment laws. So I don't know, that's an example of the sort of work that might have plausibly been partially US government funded, but I'm honestly not sure. It's a really interesting question in the agenda. There's a couple of hands have popped up. I'll get.
Okay, Mavluda.
That brings to mind, that's a really good question. And that brings to mind one of the very fascinating insights I had when interviewing government officials in one developing country, where I said, well, where do you get all of your learning about investment arbitration? And they said, oh, we have this regular arbitration conference where the sharks of the international arbitration community come and teach us about international investment law. So there we go. Your foreign advisors may come in different shapes and guises, and they're not necessarily always funded by bodies such as USAID. And it's actually a very interesting question indeed, a research question as to, where do we look for those advisors, and to what extent, say, arbitrators and, the legal industry, practitioners of investment law acting in an advisory capacity, what does it tell us about the functioning of investment regime, shaping of it, and so on?
Thank you. This is sort of suggesting the creation of an arbitral industrial complex of sorts. Watch this space. Lauka, you had your hand up. Is that right?
I think so. I agree with Jonathan. My sense is that the history of sort of US support here was more indirect. So in Eastern Europe, the American Bar Association was absolutely critical during the early 1990s, sort of after the Cold War, sending American lawyers and previous treaty negotiators to Eastern Europe to help reshape constitutions and investment frameworks, and including also engaging on investment treaties too. But on this point, I think, and this is, I'm not going to be making any friends here, but I actually think, in addition to, I guess what I would say, the usual suspects of sort of advisors being arbitration practitioners and the various questions that come with that, maybe it's also worthwhile having some real critical engagement from a research perspective on the role of different NGOs and international organizations in providing similar advice and their mind maps and the sort of advice they provide, to make sure, because I think there's actually well, I know there's a lot of activity on foreign advisors being sent by different NGOs and different civil society groups, and that a lot of that is probably very, very valuable. Full disclosure, I've been involved in some of that myself, but it strikes me that a lot of the policy debates around the interesting questions around being a foreign advisor and the various sorts of mind maps and possible conflicts that come with that could equally potentially in some contexts be applied also outside of the private bar to some of the huge suppliers of advice which come from the civil society community.
Yeah, that's a really great point. Nicholas.
Yeah, very briefly, and I mean, with the same, following the same line, I mean, probably also not making a lot of friends. I think sometimes there is a question, I mean, going on the sort of, balance of power, north-south dynamics, that a lot of that knowledge flows from the north to the south. So you have people from the north telling people in the south how to do things. And there is a question of creating capacity. And I have made this point to a couple of NGOs, think tanks. You need to create capacity in the global south so they also can stand to the discussion when they want to investment treaty reform in countries, I don't know, in Latin America or Africa or Asia. Because otherwise the conversation is always happening within the global north space and just popping up in the south just for some events or political situations, but there's no civil society in these parts of the world. So you always need this kind of, foreign advisors flowing from the north to the south. I think if you really wanted a more like systemic reform of the regime, you would need to create this sort of critical mass in the south as well. Yeah.
Absolutely, yeah. I am afraid that that's all we have time for today. So thank you so much to SIEL for hosting this, to our speakers and to you, our audience, for such an enriching conversation. Keep an ear out for the next conversation. I hope there'll be another one this year, but I am not entirely sure. And have a great day wherever you may be. See you.